Hello, this is attorney Vincent W. Davis, and I've been practicing law here in California for almost 40 years, with a major part of my career focused on CPS and juvenile dependency defense. Today's topic is one that thousands of parents deal with, but very few understand. What should you do if you believe a CPS social worker lied about you in a report to the judge? If you think a social worker misrepresented facts, left out important information, or outright fabricated statements, I'm going to tell you exactly what to do and what not to do. Make sure you watch this until the end because the last two steps are where most cases are won or lost. If you're watching this video because you just read a jurisdiction disposition report or a last-minute addendum and you saw lies, distortions, things that never happened, quotes, you never said allegations that came out of nowhere, you are not alone. This is more common than you think, but here's the critical part. You cannot respond emotionally, and you cannot confront the social worker directly. Why? Because anything you say can and will find its way into a new report, usually taken out of context. So the first rule is simple. Stay calm. Do not react. Do not fight with the worker. Do not send angry texts, emails, or voicemails. We're going to handle this strategically and legally. You need every word that the social worker submitted to the judge. That includes jurisdiction reports, disposition reports, court addendums, contact notes, team decision meeting notes, police or third-party attachments, information for the court memos. Ask your attorney for everything filed with the court. If you are self-represented, politely request copies from the court clerk or your court-appointed attorney. Reason: you cannot challenge something effectively unless you have the exact written statements. This becomes evidence later. Once you have the report, you're going to create 3 columns: what CPS wrote, what actually happened, your proof, texts, screenshots, witnesses, timestamps, photos, videos, police reports, therapist notes, etc. Let me give you an example. CPS wrote, mother refused to drug test on March 15th. Actual truth, mother was never contacted on March 15th. Proof, screenshot showing no missed calls, no voicemail, and no testing order for that date. Another example, CPS wrote, father became aggressive during interview. Actual truth, father calmly ended the conversation after the worker raised her voice. Proof, recording, if legal, or a witness who was present. The key is this. Never say they're lying unless you have documentation. Judges respond to evidence. Start building your evidence binder immediately. Anything that contradicts the report is gold. Preserve. Text messages between you and the worker, emails, call logs, photos, video recordings. Check California's 2-party consent rules, certificates, test results, appointment confirmations, police body cam footage. Yes, you can request it. Make backups in 2 places, cloud plus device. CPS cases move fast. Evidence disappears. Phones get broken or replaced. Workers rewrite history quickly. You need your receipts. Parents often lose cases not because CPS was right, but because they reacted the wrong way. Do not call the social worker a liar email. The social worker accusing them of wrongdoing. Argue with the supervisor post about the worker on social media. All of that gets twisted and used against you. Instead, let your attorney raise the credibility issues in court. Your lawyer can file objections. Bring the social worker to the stand, cross-examine them, introduce your evidence, motion the court for sanctions, request a corrected report, challenge the findings, request an evidence code section 730 expert. Ask the judge to order the department to amend inaccurate information. This is why documentation matters. Your attorney needs ammunition. When a social worker lies, exaggerates, or misrepresents facts, the best remedy is cross-examination in court. During the jurisdiction hearing or any evidentiary hearing, your attorney can ask, how did you verify this statement? Did you record this interview? Where are your notes? Did you ever speak directly with the parent? Why is your report inconsistent with the police report? Why did you omit these facts? Isn't it true you never contacted the therapist? Isn't it true the drug test results were clean? Isn't it true you visited only once in the last 60 days? Most workers are not prepared for aggressive cross-examination from an experienced attorney, and judges do pay attention. If credibility collapses, the judge can disregard parts of the report, order corrections, order additional services, reduce findings against you, question the department's entire case, lean toward reunification or return. You'd be surprised how often the court changes direction when evidence exposes inconsistencies. Filing a complaint should not be your first move, but it can be part of the strategy. After documentation is complete, you can file with County CPS Supervisor, County Director, Office of Civil Rights, California Ombudsperson, Local Grand Jury, Federal Civil Rights Divisions. Rare, but possible. Your complaint should be short, factual, supported by evidence free of emotional language. Something like, the worker stated A, but documentation shows B. This is affecting parental rights and court orders. Please investigate. Never use liar, corrupt, or insults. This can backfire. Your next hearing is your opportunity to correct the narrative. Prepare a timeline, a binder with all evidence, a short factual summary of inaccuracies, witness names, your compliance documents, questions for your attorney to ask the social worker. Your goal is to shift the judge's perception of you, not fight with CPS. California dependency courts rely heavily on credibility, compliance, documentation. If you bring solid evidence and remain credible, you stand a very strong chance. If you believe a CPS social worker lied in a report, do not panic. Do not fight directly with CPS. Do not rely on emotion. Instead, gather documentation, preserve evidence, work through your attorney, expose inaccuracies through cross-examination, change the narrative with facts. I've seen families lose their kids because they reacted emotionally, and I've seen families get their kids back because they followed a strategic, evidence-based approach. If you want more videos just like this, make sure you subscribe, like, and drop your questions in the comments. And if you need help on your case, you can reach my office at 888-888-6582. This is Attorney Vincent W. Davis. Stay strong, stay smart, and I'll see you in the next video.